control order, reaching to the destiny, or punishing innocents.
Good afternoon, ladies and gentlemen from the international academic and legal practicing community. So if I may, let me introduce myself. My name is Mohammed Shahjalal, and I'm a PhD student from Glasgow Caledonian University. And me and my supervisor, Dr. Mahdi Zahra, would like to thank all of you for being kind enough to become my audience. Thank you very much. However, this is something different from the booklet. I do apologize for that because at the last minute, actually, I wanted to. No problem. Go. Okay. At the last minute, I thought rather than explaining what counterterrorism is, because we all know more or less what terrorism is, what's bothering in the modern world. So I thought let's take two specific elements of counterterrorism, which is, as you can see, judicial independence, and I'm not really happy, so that's why I put the contemporary title on it, and obviously the national security policies. These are mainly two core elements for countering the terrorism issues. So if we can move on. Next slide. I do not expect, I do not expect all of you to have the same legal background which I want to talk about today. So I wanted to make it absolutely plain and simple. So apologize first of all, because I made it very simple, so that all we can understand what the general theory things are. So if we follow the slide, today's discussion topic is on contemporary judicial independence and national security policies. So what basically meant was, for me, that counterterrorism is whether counterterrorism measures for the judicial independence or national security policies, which one is lesser effective and more inappropriate to eliminate terrorism. These are the comparison between these two. So obviously you can see the first slide, judicial independence. In theory, we need to understand in brief, obviously, because of the time restraint, that what judicial independence really means. Judicial independence is the concept that the judiciary needs to be kept away from other branches of government, and which basically means courts should not be subject to improper influence from the other branches of government or from private or partisan interests. For example, some judicial elements like rule of law, as you can see, no political interference, no undue influence. So what it actually means, but I actually wanted to argue about this, is rule of law must go in its proper way. So obviously, sometimes legal matters are not the end of the world. If I may, that suppose there is a crisis going on. So, and the court made a judgment, which is not really compatible all the time, because suppose due to insufficient evidence, a court make a terrorist go free, and he then he becomes a threat imminently in the next time. But you see the procedure, the strict limited procedure, all know that he will do harm again. But that the judge who sits on the chair cannot rule by presumption or common sense. That's what I actually wanted to mean. So if I may go on the further explaining, the national security policies, like the national security, oh, sorry, the next slide, thank you. Oops, that's the one. That's the second element. National security is a concept that a government, along with its parliament, should protect the state and its citizens against all kinds of national crises and crises through a variety of power projections such as political power, diplomacy, economic power, military might, and so on, especially some contemporary elements like espionage policies. We all know how many movies been made on this these days. We don't know how many debates, what CIA should do, what MI6 should do, what should not do, what's good on them, what's bad on them. The military policies, some says that the West should not be engaged on a war. No threat, absolutely no threat. Suppose I don't want to name those terrorist organizations due to sensitivity. Some people think that these are innocent people. They're no threat. And some people think that, of course, we should diminish them on the ground and make them not visible anymore. So which one is true and which one is right? Which one is justified? Military policies come out with these enormous contemporary debates. And the second one is international treaty and relations. How many treaties been signed? As I followed some of your presentations, many refer to the treaties and relations acts. Is it really viable, feasible every time that we sign in a treaty, or each one of the countries sign in a treaty, and it's adequate and sufficient for them, for every country? If that is, why there are too many violations? Suppose, if I may refer, Hitler signed a treaty long before the Second World War, I think 1934, with that time the Soviet Russia, with Marshal Stalin. And they said that we should sign this treaty for peace, that will not invade each other, will not use the force for 100 years. And Marshal Stalin said, no, not that much, because the people will think that we're not being serious. And after 5 years only, in the 1940s, Germany attacked Russia. And what happened? They simply breached out the international treaty and relations, the promise. So that must not be serious. It's like we began something, and if we think that's it does not fit for us, I will breach it. Oh, but I promise that I'll keep to my word. This treaty will not be breachable. But if I want, I'll breach it again. So what is the consistency? So if I may go on. So again, we go back to the terrorism, because that's what it is. That's why I'm here. The counter-terrorism issues. So there may be no doubt that terrorism poses a considerable portion between these two elements, as I discussed before in my other slides. Of course, this research will continue its discussion by comparing legal trials and cases without mentioning, as you might as you might understand already, that I haven't referred any kind of cases name or something like that, because I don't want to, due to sensitivity. And also, I will go like this: in a decided case. So first, a case from UK. I'll refer it as in a decided case from UK, where an individual, I'll not say the name again as well, because I didn't have permission, to be honest. That's why. That individual was being prosecuted in suspicion of a terrorist plot in London, even though he was entitled certain legal privileges. Obviously, anyone could understand, anyone could guest, that should be human rights. That's the basic right. So legal it should not be labeled as legal privileges as well. It comes automatically. You will understand why later. The legal privileges, but the judge refused to comply with them. Suppose in a live trial, if a defendant does not want to answer any question in a cross-examination, that's his right, isn't it? Maybe it's incompatible with the court procedure, but if he thinks, no, I don't want to answer this question, it breaches my privacy, or only he knows why he doesn't want to answer that. Should it not be his legal right? But the judge refused to comply with it. He emphasized that honoring the privileges, actually in that case, he wanted to speak with the press openly about his ongoing trial system. He was not happy with some issues. So the judge said that honoring the privileges may discontent the image of the government and so forth. It might cause mass disruption, and it might distort the image of the government, who are really with all their heart fighting with terrorism. Because obviously these issues are inseparable from politics as well. So, government should have some privileges as well. That's what the judge said. So, regarding this, the leading jurist and academic from the international community argued, and the summary of the argument was, in one quotation, that even if the Satan, the devil, yes, can be accused of in a trial before God, even for his case, no influence should interject any rights of him or authorized for him, irrespective of how difficult or how important the situation is. So in a plain meaning,